Just one other thing, if I could add to that, Gary. Just this is a little off the subject of employment, but for those of you that work in other areas, be aware that there are holes in the statute as far as who it applies to. For example, I've got a situation now where I represent some folks that are members in an LLC, and there's some non-compete language within the operating agreement of the LLC. Well, if you read the definition of employer and employee and to whom it applies, there are definitions. There's things like partners and partnerships, there's franchisors and franchisees, but there's no reference to members in a limited liability company. So I think that there is a good argument to be made that the statute does not apply in that scenario, in which case that leaves you scratching your head wondering, well, then what law does apply? I think without the statute, then you just default back to the old common law. So there's things like that. Another one is it only applies to sellers of a business if they own 25% or more of the business. We've got a corporate group in our firm, and they had a situation where they were representing an acquiring company, and there were people in the selling company that owned less than 25% that they wanted to have signed non-competes. And so, we said, look, I think you've got to comply with the old common law in order for those non-competes to be enforceable, because the statute only applies to sellers that own 25% or more. Now, even under the old law, as we were talking about earlier, the scrutiny that was provided in the sale of a business context is much different than in the employment context, but the rules still are a little different, and you have to be cognizant of that if you're drafting a purchase and sale agreement in which you're having people sign covenants and they own less than 25% of the business.